move to the Riccarton Wigram Community Board because the people who made Sarah and Cara are still here. But Mike, come to the table, mate. And also Paul is here, who might want to give information on the Roberts Road resource consent application requirrying, if anybody has questions on that. Okay, Mike would like to very briefly introduce this.
I just had to get Maslow's hierarchy of needs sorted.
So what, you needed shelter first?
Might have been the smoke and the coffee. Mayor, thank you very much for the opportunity.
They don't appear on Maslow's hierarchy.
I've been up all night, so I need something. Thanks very much for the opportunity to present our board reports. Our first one is on page 107. And the board submissions, we've dealt with that one. It's part A. And we're happy with the outcome of that. The Roberts Road resource consent applications re-quarrying. As you're aware, there's 2 quarries planned for Roberts Road. Our board and the local community have got some concerns about the proximity to well-established residential neighbourhoods. So we wouldn't like those people shut out of the opportunity to be able to make submissions on this, because it is quite a lengthy period of time that the quarrying will be going on there. So I just think it's fair as advocates for our community to request that serious consideration be given to it being publicly notified.
Okay, thank you. Is there anything else you want to draw to our attention? Because I am then going to get Paul to come to the table.
In relation to the Roberts Road one?
No, just the whole report.
The whole report?
Yep.
Just let me flick through.
There's no other part A's.
No, that's it.
Cool. Okay, thank you. So in relation to part A, obviously part 1.1 has been dealt with under the Spraden Heathcote Community Board, because it applies equally to all community boards, obviously. Item 2, in relation to Roberts Road, there is a letter from Paul Rogers, who's here. Do you want to come forward, Paul? And his advice, have you all received this? Okay, so his advice is that the council should pass the community board's recommendation on to the appointed commissioners for these applications, so that the desire of the community board to have these publicly notified is actually passed on to the commissioners.
Yep.
Is there any questions? And this is addressed to John Higgins. So John and Paul are there. Obviously it's an issue that may come up. It actually arose originally in the Fendleton Waimarie Community Board. Are there any questions of either John or Paul? Jimmy, then Yanni, then Phil.
Okay. Advice. I read the list and the report. I ask you, because based on the RMA, the Act, whether to go to the notification or not, that's either the staff, the planner, or the independent commissioner, the responsibility, jurisdiction. So if the independent commissioner say, no, not go to the notification, but whether all those affected the residents might have, the impact about this issue. So how to remediate this situation?
Thanks.
Yes, good morning, councillors. As I understand the question, if the independent commissioner who's appointed makes the decision that these applications will be notified, then they are open for submission from parties who may or may not be affected by the application. Members of the community can lodge a submission. If the Commissioner says, yes, this should be notified, then it's open for submission from all community members.
The Commission say no. What's going on? You say no.
If the Commissioner says no notification, then obviously that's what follows. The Commissioner, before he or she made that decision, would of course take into account the requirements of the Resource Management Act. They'd be carefully considering the issue of effects that might arise from the application, and they would need to make a decision in accord with the Resource Management Act about notification or not. If somebody's disappointed with that decision, there's only one real route of challenge, and that is to judicially review that independent commissioner's decision.
Okay, I'm just getting copies for you because I appreciate that you haven't got the letter from Paul Rogers to John. So I'm just getting copies of that made. Yanni?
So my understanding of the RMA is that there's a provision to publicly notify or limited notification based on special circumstances. In your view, would these quarries meet that test in terms of the proximity to a residential area?
Unfortunately, I don't have the detail on the actual applications themselves. All I understand is that the applications are making their way through the resource management process. So I haven't turned my mind to the issue of whether or not notification should or should not occur.
Just in terms of the ability for council to use special circumstances to notify applications, is there any general advice that we can be given on that? Because I personally don't quite understand why we couldn't use that as the reason to support what the community board had requested.
So we have legal advice on special circumstances relating to other applications, but we don't have any yet relating to this specific application. But at this stage, it's just going through the process and being assessed, and we are looking at obtaining a legal advice around special circumstances specific to this particular application.
Can I just clarify, Paul and John? So if we pass today that the community board and council's desire for these notifications to applications to be notified, be passed on to the commissioners, that's within the law.
Yes, that's the advice I've proffered is at paragraph 16 of the letter.
Yeah, I'm just getting the letter photocopied. Sorry.
And that's my advice, and that's based on making sure that there is a correct process for processing the resource consent application. Okay, thank you. I've got Phil next, then Glenn. Right. Okay, Glenn.
Thank you. This may be covered in answering that previously. It's more around it's not the notification I have trouble with, but possible precedent setting. So will that be covered off in the legal advice? I think, John, that if we approve the board's recommendation?
So you mean in terms of the board's recommendation to notify this application? I don't think there's so much concern here. It's more that each resource consent application needs to be assessed on its merits and the facts and on the information.
It's more opening up a precedent, though, for other boards to do this. And
yeah.
Well, that's one of the issues.
Exactly. It's exactly what it's doing. Yeah. Just the only difference between paragraph 16 of your letter and what I was suggesting was that I was going to include the council's desire as well as the community board's. No problem?
That's available because the Commissioner ultimately will be making the decision about notification or not.
Okay. Okay. Thank you. Are there any further questions, or do you want to take a couple of ticks to Yanni?
Does this have to go to a commissioner? Could this not go to, I think we've got panels of elected members or of council staff. Why is it going to a commissioner?
The reason why we thought it was appropriate to go to a commissioner was one, because it's a joint application with Environment Canterbury and City Council, so there's issues there because obviously environment, they'll be jointly heard and jointly considered, and they have their own, they use commissioners of course, and they wouldn't use elected members, so it creates issues in that respect. Also in relation to this recommendation from the board, there's obviously would be concerns from the applicant about getting a fair hearing.
Okay, yep, that's fair. Okay, Can I suggest a way forward then, that the Riccarton Wigram Community Boards and the Council's desire for these to be notified be passed on to the Commissioner, which is basically your suggestion in the letter. Okay, so if I move that and Jimmy seconds, can I put that in debate? Put that. Those in favour, please say aye. Aye. Those opposed? Carried. Thank you. Thank you very much.
Good.